Mr.
Hello?
Harris, are you driving?
Just give me 1 second. I'm parking right now.
What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 2 to 4 weeks if the court would allow.
Okay. So maybe I don't understand something. And he was just driving. And he didn't have a license. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up.
Got it.
But I can make the August one work and I'll leave that open and we'll get it done.
Okay. Jury final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you go.
I was going to try to get you. I was going to try to get you out of the room. Bloom. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not driving with a suspended license.
Welcome back, everyone. Today, we're witnessing absolute courtroom chaos with Mr. Harris starting the day by joining a Zoom hearing while driving. Yes, you heard that correctly. The judge's reaction? Pure disbelief. Not only was he driving without a license, but the legal stakes are huge. A bench warrant looms if he doesn't turn himself in. This opening scene sets the tone for a wild ride, reckless behavior, serious consequences, and a rare moment when someone's courtroom antics go viral for all the wrong reasons. Stay with us, because later we'll unpack every twist, every outrageous claim, and the jaw-dropping rulings in this hearing.
2 times now I've let it go. Remember?
Let what go?
I said enjoy the day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given the hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it, but hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
Hold. This is why. Listen, Mr. Bernstein.
Which discovery referencing, Jeff? Hospital report that Deputy Swearing says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report.
Mr. Bloom.
Okay, I'll let it go.
Because you keep asking me questions you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
Per transcripts.
No,
I still haven't received the transcripts.
Of what?
3-6. Remember I asked for the transcripts from 3-6? I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, again, you have an attorney. Tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are.
Now, let's pivot to Jeffrey Bloom, a man whose courtroom history is almost legendary. Multiple lawyers, messy domestic violence charges, and courtroom antics that could fill a full season of drama. Today's pre-trial hearing is no different. Missing evidence, endless delays, and Bloom behaving more like a law professor than a defendant. His confidence is striking, but it raises eyebrows as his arguments feel more performative than substantive. And here's the kicker. The courtroom starts feeling like a stage. You can already sense this case is going to be chaotic. What would you do if you were the judge handling someone like Bloom? Drop your thoughts.
I don't
Professional
have that,
real.
but go ahead.
I can clarify what Jeff's talking about. I ordered an audio recording of that hearing. And someone in my office kind of like, we did a transcription of it for Jeff, but I think what he wants me to request is an actual transcript, and I just didn't.
Well,
wait for
and
speeding
so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received a written request for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. Per transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff 22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff's Deputy says.
hold on a second. What are you reading to me right now?
Something that I want to state on record, Your Honor.
No,
Is that-
but
can
what
I do that?
you're obviously stating what somebody else said. I'm just
No.
trying to figure out where it's coming.
You said,
On the 24th of,
no, on 10-4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority of authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10/4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be
Okay,
in
well,
regard to your
I'm
other
trying to
matter
put-
because
I'm
this
trying to
didn't
put
start.
canons.
No, stop. This case didn't start until 10/18. So if you're referring
Okay, I'm
to a
past that.
record from another case,
Then I'm past that.
then you're past what?
I'm past the other case.
Things get intense as Bloom starts arguing over discovery files, hospital records, and transcripts that may not even exist. He's convinced there's a massive conspiracy, and he's determined to unravel in real time in court. His nonstop objections threaten to stall the hearing, and the judge has to balance patience with firmness. This is a textbook example of courtroom procedure versus performance. Etiquette rules and timelines are being challenged at every turn. And for viewers, it's fascinating because you get a front row seat to both legal strategy and human behavior under pressure. Notice how the judge repeatedly tries to bring focus back. It's a lesson in maintaining control amid chaos.
Canon 2, Canon 2A, Canon 3, which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court, it is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3/6, Your Honor, where you stated you had notes, you stated you had a phone call from ex parte communicators.
No, that was regarding your dental.
Yes.
Yeah,
Yes,
has
that was a
nothing to
motion
do
we
with-
filed. Your
No,
Honor.
but that has nothing to do with the
But
case.
I mentioned that on
And
other days you did
but
that.
Mr. Bloom, no, Mr. Bloom,
You don't
because
wanna
if you're
hear it.
going to, you don't want to hear, I don't. Because what
know.
you're saying is incorrect.
Okay,
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
there were other
But-
matters you did the same thing, Your Honor.
Bye.
I'm not contacting.
Goodbye.
Senior
Goodbye.
Commission.
Goodbye,
I'm not
Mr. Bloom.
contacting-
Goodbye. Thank you. Have a great day.
Like your horse.
Take care.
We'll contact the Senior Commission.
Mr. Harris, how are you, Your Honor?
We will see.
We're good. We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance
Oh,
I
I've
get a
got a
substitution?
substitution right here.
signed off on.
It is.
All right, then I don't need to address. I don't need
Thank
to
you.
address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance and I will sign off on the substitution.
Thank you.
Thank you. All right. What are we doing today?
So, Your Honor, we were going to, there are several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particular.
Bloom escalates further, quoting legal ethics and courtroom rules as if writing a live legal blog, but Judge Simpson isn't buying it. The judge firmly points out that Bloom's arguments are not just off topic, they're factually wrong. This moment is both dramatic and instructive. It reminds everyone watching that courts are governed by rules, and no amount of theatrics can change that. Bloom doubles down on claims of bias, and while he's passionate, the judge holds the line. The courtroom feels almost like hosting a debate no one signed up for. And for viewers, it's a lesson in the difference between confidence and credibility.
Some of Mr. Harris's comments with reference to this court potentially acting, what at least as I'm to understand, is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments, as is my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong, and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license, let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever, and has never had a license in the other 49 states and Commonwealth.
And now we return to our viral Zoom star, Mr. Harris. His lawyer speaks up, and suddenly, the courtroom learns that some of Harris's records were outdated and inaccurate. The judge acknowledges a system error, but make no mistake, Harris still never held a valid license. This isn't just a minor mistake. It's a fundamental legal failure. This revelation shifts the hearing's tone instantly. You can feel the room's tension spike as the cold hard facts land. Even minor errors in public records don't absolve someone of their responsibility. For viewers, this is a perfect example of accountability hitting in real time, and the drama is palpable.
When they suspended his license, and what people don't understand, when they suspended his license in Saginaw, they don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said but it doesn't matter because he didn't have a license ever. There is also then, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was, his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's then an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a reinstatement. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You're covering a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th date. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that wasn't paid. Now, here's the other thing,
Here's a deep dive into legal nuance as Bloom brings up canons 2 and 3 regarding ex parte communications, trying to link unrelated dental motions to procedural bias. The courtroom exchanges are dense, and it's a lot to follow. But here's the takeaway. The judge methodically separates what's relevant from what's not. Bloom's attempt at legal gymnastics are impressive in theory, but in practice, they don't hold water. This segment highlights the tension between technical legal knowledge and courtroom strategy. For viewers, it's a masterclass in understanding how courts filter out distractions, maintain fairness, and keep the focus on facts rather than speculation.
this stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me. so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved into the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of counsel, defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 28th, 23.
23rd.
2023.
I know I was laid up from my
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you redid and got your new Michigan ID, December 28th, 2023. You did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, 1990, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do. You cannot have both. You either have an ID or you have a license. One of the two. He has religiously every year gotten a new ID. And so he knows.
The judge now addresses Harris's claims of faulty information, carefully explaining that while there was an error in the records, the burden was always on Harris to ensure compliance. The courtroom scene is tense yet instructive. This is one of those moments where the law and real life collide. Systems can make mistakes, but individuals are still responsible for understanding and acting within the law. The judge's clarity and patience in explaining this are remarkable. For viewers, it's a reminder that accountability, procedure, and understanding one's obligations matter as much as dramatic courtroom.
That he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Fiasco Township Police Department with Officer Monaster, who performed the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license, close quote. The question was, are you a valid driver? Quote, I am not, close quote. So, you know what, this is all this hoopla and the circus atmosphere is, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court, It wasn't caused by the Pittsfield Township Police Department. It was caused
Go
by
ahead, counsel.
Thank you, Your Honor. Thank you very much. Well, first thing I'd like to say is, very first thing is we're here and that we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court today, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that just became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla whatsoever. That was someone that was outside over there. And that I'm going to stand on that. He did not send it out to Instagram. He didn't send it out to wherever. He didn't do that part. So with respect to, did he have I don't want to try this case today at all, but what I want to do is focus on what's good. Now, what was good? That day in October, this officer here, that could have gone a whole other direction. And I'm so happy that you were so kind and courteous to my client. Thank you, officer. Thank you so much, because it could have gone another direction. We are here right now. My client has an appointment to go to the Secretary of State for his permit. He's working on that. I want to focus on how do we correct this and cure this? How do we go forward with this situation? Whatever, he was not under oath under any of the things that he said. So we're not talking about any type of perjury going on. Very true, right? True. So with that being the case, let's move forward with this. He is here. This is what I'd like. Because
Counsel, let me just.
Yes.
I would like to move forward too.
Yes.
On this case. We handle these cases all the time. But I will tell you, as you know, having appeared before me, the one thing I don't like is when people don't take responsibility for what they've done. When they take responsibility for it, we will use whatever we can to try to get you to another spot, because it doesn't behoove any of us for you to be in that spot. One other thing that I will say, when you say it wasn't started by him, oh, it certainly was. It certainly was when he made his first statement to WXYZ about blaming people for this happening.
So here's what we learned from this whirlwind of courtroom chaos. Mr. Harris faced serious consequences despite system errors, and Bloom's theatrical tactics illustrate how not to handle procedural disputes. The judge consistently enforced rules, clarified legal misunderstandings, and maintained control over a challenging courtroom environment. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. From viral Zoom antics to procedural showdowns, these hearings remind us why courtroom drama is always captivating, real, unpredictable, and full of lessons.